Hello, I'm Vincent J. Russo with the Russo Law Group and co-host and creator of Family Comes First on CFN. Today I want to focus on two legal updates, one as to the New York Medicaid Home Care Program and the other as to the power of attorney statute in New York State. These changes are coming, and I want you to be aware of them because it may have a significant impact on you or a family member. As you may know, the Medicaid Home Care Program is an essential program for seniors and people with disabilities in New York. This program allows seniors to age in place by accessing Medicaid home care for their long-term care needs, while being able to protect their assets and income so they can cover their living expenses. This allows seniors to be able to live independently at home. Qualifying for Medicaid is critical because Medicaid is the only government program that covers long-term care, assistance with activities of daily living. Medicare does not cover long-term care. But one needs to be aware of the Medicaid program's strict financial eligibility rules. These requirements will be even more restrictive when the new laws come in. For now, the existing rules still apply, and there is no transfer penalty or look-back rule. One can divest of their assets and qualify for Medicaid. What I mean by that is that the new rules, once fully implemented, will disqualify a Medicaid applicant if they have made a gift of assets, for example, money, within a 30-month period of when they apply for Medicaid. A transfer penalty will disqualify seniors from qualifying for Medicaid for a certain number of months based on how much the senior gives away if the gifts are inside that look-back period. One should note that there are exceptions to this penalty rule, such as transfers between spouses or to a child who is disabled. These rules are very complex and not always rational or fair. If these changes are implemented, many seniors and people with disabilities will go without care. In addition, many seniors will not be able to continue to stay at home or in their apartment, and they may be forced into nursing homes. My hope is that the law will not be implemented, but that will take significant efforts on the part of advocates and the citizens of New York. Even though these changes were passed in 2020, the good news is that they have not yet been implemented. The earliest would be July of this year, but it is likely that the new rules will not be implemented until sometime in 2022. So, we will just have to wait and see when New York decides to implement these changes. As I said, likely in 2022. For today, you may be asking, what should seniors do now in light of these changes that are coming? I would recommend that you plan now to protect your assets by meeting with an experienced elder law attorney who can help you. File for Medicaid home care if you need long-term care services. And don't wait, file now. And advocate for legislative change. The second legislative change that I want to talk about is the Durable Power of Attorney statute. A power of attorney is a legal document that allows you to designate an agent to make financial decisions on your behalf if and when it is necessary. A comprehensive durable power of attorney is a critical part of one's estate plan to protect and preserve your assets. We have a new durable power of attorney statute in New York coming into effect June 13, 2021. This means that if you have a statutory durable power of attorney in effect before that date, it is still valid, even after June 13th. If you are signing a new power of attorney on or after June 13th, then you would want to make sure you are doing so with the new statutory form. The power of attorney form will be easier to understand and execute. The statutory gift rider has been eliminated. There will no longer be two parts to the statutory power of attorney form. This will eliminate confusion as to the signing requirements. Lastly, there will be greater acceptance of the statutory power of attorney as the courts now will be permitted, under certain circumstances, to award damages when your power of attorney has not been accepted by a financial institution. These changes will be helpful in ensuring that your statutory durable power of attorney will allow your agent to make financial decisions for you as you have set forth in the document. Again, the key is to seek the advice of an experienced elder law attorney who can make sure you have a comprehensive plan in place to preserve your dignity and protect your assets. Be well and be safe. This is Vincent J. Russo for CFN in the Legal Know.